Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be discussing basics of the Sunshine Act, also known as Pennsylvania's Open Meetings Law. A couple preliminaries before we jump into the session. First is that if you've never attended one of these webinars before, it's basically a PowerPoint presentation with me talking in the background. The PowerPoints are available on our website, where you go over to the training tab and scroll down, and you'll find actually all of the PowerPoints that we use for our trainings, and you're welcome to use any one of those. Perhaps you have a colleague who wasn't available to attend this morning. You might want to just use it for your own future reference, or maybe you're doing some local training. Well, the resources are available for you to use. Also, this session is being recorded, and within a couple days after the recording, it gets loaded to our YouTube channel, and then we establish a link also on our website. Again, go to the training tab, and it's not hard to find. Most of the recent webinars you'll find there. And again, you're welcome to download those or reference them for whatever your needs might be. They're considered public records, so have at them. If you have questions this morning, you can use the chat feature to type in, and I will do my best to answer the questions as we're going through live. Pardon me. However, two conditions. First is that we are talking about the Sunshine Act, so let's try and stay on topic. Second, and probably more importantly, is if you can keep your questions as brief as possible, it really is helpful. Oftentimes, if someone types in several paragraphs, it's just awkward for me to sit here, read through them, and then come back with a response while everyone else is patiently waiting. If you have a situation that is unusually complex or specific to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll do my best to come back to it and answer it for the good of the order, or we'll take the conversation offline, and I'll encourage you to reach out to our office. The phone number is on the screen right now, as well as the URL for our website. On that website, we have access to email accounts that you can send in your questions. And either way, phone call or email, we have a crackerjack administrative staff who will be happy to get started with responding to your questions. If they can't answer your questions, then it'll get escalated up to one of our senior staff members. And we do our best to get back to you within 24 hours of you submitting your questions, because we figure, if you're reaching out to us, there's a good chance that, number one, it's important, and number two, it's time sensitive. So we want to try and get back to you as quickly as we can, and we're usually pretty good about that. Okay, so I think that takes care of all the preliminaries. Let's go ahead now and jump into the session, Basics of the Sunshine Act. And I want to begin by talking about why the Sunshine Act is important. And like I said, it's also known as Pennsylvania's Open Meetings Law. But I'm going to pull out of the, what would be known as the preamble to the law. And just bear with me here. It's the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, and decision-making of agencies. It's vital to the enhancement and proper functioning of the democratic process, and that secrecy in public affairs undermines the faith of the public in government and the public's effectiveness in fulfilling its role in a democratic society. Okay, a very altruistic statement, but yet having worked in this area for nearly 10 years, I have to tell you it's spot on. When there's an abuse of the Sunshine Act, it really is undermining our democratic process. And I've been fortunate enough to travel to other countries where, even though they were, quote, democracies, unquote, they did not have the opportunity for members of the citizenry to stand up and directly address their public officials over matters of import. This is unique to our country. It's unique to Pennsylvania, and it's something that should not be taken lightly. So when there is an abuse, it's taken seriously, and there is an appropriate response. Okay. Now, I like to, in these sessions, define the Sunshine Act as a three-legged stool. When someone calls into the office and they're concerned about what their public officials are doing related to public meetings, I focus on three areas, or we focus on three areas. Was there advance notice of the meeting and instructions for people on how to attend? Meaning where, excuse me, where was the meeting? If the meeting has an online component, okay, how do I log in? How do I get to see what's being broadcast? Then does the public have the opportunity to observe the deliberations? And deliberations has a specific meaning, a specific definition that we're going to be talking about here further into the presentation. And then was there the opportunity for the public to comment on these deliberations prior to any decision being made? Okay, so we look for those three components as to whether there may have been a violation or a misunderstanding relative to the meeting that was held. Okay, well, let's begin by talking about who is covered. And we look at the Sunshine Act itself and the language that's in there. And, granted, many of these laws are written by people in the legal profession, and sometimes they can be difficult to understand. And I always tell people that when you're trying to understand how a law works, don't just read the law itself, but take a look at the definitions and, example after example. There may be cases where language appears unusually vague, or you think there's a conflict in how the law is written with its various provisions. Oftentimes, you can go to the definition section of that law, and it will provide you with a source of clarity as to what the language actually says, what the law actually means. And the Sunshine Act is no different. Okay, so the law says that it applies to any state or local government body and all committees. And that phrase, all committees, is important because a lot of times there's disagreement as to whether a gathering is subject to the Sunshine Act. And I'm going to talk about that in detail here. Okay, well, then we move up to that perform an essential government function. Okay, what does that mean? Well, let me put out an example here. Let's say that within our township, the local girls softball team has won the state championship. Okay, quite an accomplishment. So the supervisors appoint an ad hoc group, a committee, if you will, to arrange a celebration. They're going to have a parade through the township, and then there's going to be a gathering at the township park where, maybe we'll have a barbecue or whatever, and we'll recognize the accomplishment of the girls softball team. Okay, now, as important as this is, as big an accomplishment as this is, I think we could argue that organizing a celebration in a parade is not an essential government function. Okay. But let's change the example up a little bit. Let's say that there is a standing committee within the township that on an annual basis, they're tasked with reviewing all statutes and ordinances to ensure that they're not in conflict with each other, they're not in conflict with any state or federal law, they're not in conflict with a standing judge's order, that the language is clear, that the ordinances are still relevant, that we need them. And then they report back to the supervisors with recommendations as to any changes that should be made. Okay, well, that is an essential government function. It's important that we keep our laws up to date. Okay, so I think you could then argue that in the first example, the girls softball team, any gathering of that committee, because it's not an essential government function, would not thus rise to the provisions of the Sunshine Act. But in the second example, because having relevant ordinances and statutes is important, that it is an essential government function, and conversely, their gatherings would be subject to the provisions of the Sunshine Act. Then we move up to the next factor, exercises authority to take official action. Okay, well, you're thinking, why would you have any sort of gathering where they don't have the authority to take official action? But this happens more often than you realize. In the first example, there may be a committee that's tasked purely with information gathering. Okay, we'd like you to go out and gather information on what other townships, what other boroughs, what cities are doing related to this subject and report back to the supervisors. Okay. They're not taking any official action. They're not recommending official action in any way. They're purely gathering and working for information gathering. Okay. And because there is no official action, again, they would not be subject to the provisions of the Sunshine Act. And then, sadly to say, it's not unusual for an elected official or a group of elected officials, when they are confronted with a particular topic that is unusually sensitive or runs the risk of having heated debate and heated feelings among the citizenry, that the best way to make something go away is to appoint a committee, but don't give them any authority. We want you to go look at this particular issue, okay? And knowing that there's a good chance that they're not going to do anything, okay? So a gathering, if they would even have a gathering of that particular committee, more than likely would not be subject to the Sunshine Act, simply because they're not going to do anything in the long run. Okay, and then I think it's interesting to make note of the definition of official action, which does include the term making recommendations. So if you have a committee that performs an essential government function and comes back to the main board, the elected board, with recommendations, there's a very good chance that the gatherings of that committee, because they're making recommendations, would be subject to the provisions of the Sunshine Act. Now, this begs the question of an often misunderstood understanding of the Sunshine Act and committees. We get the question quite often, does the committee need to have a quorum of the elected officials on it in order to be subject to the Sunshine Act? The answer is no. As a matter of fact, the committee is not required to have any elected officials on it. It's what the committee is responsible for per these data points listed on the screen right now, okay? Whether or not the committee is subject to the Sunshine Act is not reliant on who's on the committee. You do not need a single elected official to be a member of a committee in order for that committee to be subject to the Sunshine Act. You simply need to look at the criteria that's on the screen right now. State or local government body performing an essential government function and exercising the authority to take official action. That authority could include simply making recommendations back to the board of elected officials. Now, there's not a lot of case law on the Sunshine Act, so we can't give you definitive guidance on what you should or should not be doing based on how judges have ruled. But there is a case out there that we rely on to expand on this. Is your committee covered? And the case is Ristow versus Casey, and Casey would be Governor Robert Casey from a couple decades ago. And in this, Mr. Ristow filed suit against Governor Casey for the appointment of a committee that was looking at some, I think some further gubernatorial appointments and some proposed legislation. But in that case, Ristow, the court does go into some language that does provide, a limited degree of guidance on this issue. Are committees covered by the Sunshine Act? And there are some questions that the court felt needed to be answered in order to arrive at a decision. First offhand, does the committee have decision-making authority? And we've kind of covered that based on the language that's in the law itself. Then are the members appointed by the board, and are they authorized to act on its behalf? Now you're going to think, well, why would there be a committee that would not be appointed by the board? Interestingly, we have found examples of what we'll call self-sustaining committees. A good example might be your local public library. And in reviewing public libraries, the governance models throughout Pennsylvania are all over the place. But a very common example might be that the board originally was appointed by the elected officials, but then when a vacancy occurs on the board, the elected officials don't get involved, but the board members, the remaining board members, go out and find a volunteer to fill the vacancy. So the board is more or less self-sustaining. They're no longer appointed by the elected officials. And usually what else you find is that the library board or whatever that board might be, they're fairly independent of the jurisdiction, whether it be township, borough, city, whatever. Okay, they do their own fundraising. They, if there's an employee, they are an employee of the library board, not the jurisdiction board, the government jurisdiction. So there is very little, if any, nexus between the appointed board and the elected board. Okay, so probably in that particular case, the library board would not be subject to the provisions of the Sunshine Act. Now, like I said, the governance of libraries are all over the map, so I don't want you to paint with too broad a brush here and say, well, libraries aren't subject, because there are many examples where they are. It's just I'm putting forth an example where they aren't. Okay, then we come to what I believe is one of the most important data points lifted or spoken to by the court. And this is, are the recommendations pursuant to statute, ordinance, or regulatory authority whereby the making or enactment of laws, policies, or regulation is the end result? Okay, in the first example of the girls softball team, okay, you're not going to find any statute or regulation that says if the girls softball team wins the state championship, you must have a parade, you must have a barbecue. All right, it's just not there, which solidifies or emphasizes the conclusion that the gatherings of that particular committee would not be subject to the Sunshine Act, because you can't find any authority for what they're doing based on statute. If, however, you would have that committee that you could directly tie back to a statute that says the activity of this committee is being performed because there's a law saying it must, then clearly the meetings of that committee would be subject to the Sunshine Act, the provisions of the Sunshine Act, okay? Now, spoken to this rather definitively. However, if you're still unsure, our recommendation is to lean towards transparency. Now, number one, I'm going to say that because we're the Office of Open Records, and we're more or less the state of Pennsylvania's transparency office. Okay, but more importantly, from a practical perspective, it just makes sense. It may be inconvenient, okay, to comply with the Sunshine Act for a committee meeting, but the alternative is much more inconvenient, because if someone files a complaint, you're then faced with what I call the straight face test, meaning, can you stand in front of a judge and explain with a straight face why you didn't open up your meeting to the public and why you may have violated the Sunshine Act. Okay, and if you can't, there are sanctions that we're going to talk about towards the end of the presentation that can be very painful for a violator. So it's much more convenient to open up your meeting, advertise it, have the public come, give them an opportunity to comment, as opposed to the alternative, which could be suffering the sanctions imposed by a judge. All right, let's move on. And we need to answer the question, is it a meeting? Okay, oftentimes we'll get a phone call. Hey, I saw 3 of my township supervisors down at the restaurant having breakfast the other morning. That's illegal, isn't it? Well, no, it's not. It depends on what they're talking about while they're eating breakfast. First thing we have to answer is there a quorum of the committee of the let's just rise it to the level of elected officials. Is there a quorum of elected officials? Okay, that's the first question we have to answer. Now, members can phone in. However, under the Pennsylvania Borough Code and under the First Class Township Code, there must first be a quorum physically present at the meeting, and then any members beyond the quorum can phone in. And when we say phone in, that could also involve using an online platform like Zoom, Teams, or whatever else you might be using. However, the connection must be direct, meaning that you can't have someone sitting there with a cell phone up to their ear relaying messages between those who are physically present and those who are phoning in. Okay, the person phoning in needs to be able to hear directly everyone who's physically present, and everyone who's physically present must be able to hear the person who's phoning in. It could be like a conference call, or like I said, an online platform that would allow that back and forth. Then we have to answer the question, is there deliberation? And deliberation, again, you'll find it in the definition section. Deliberation is basically any discussion that can lead to a decision. And the deliberation would have to be about the business of the government entity. Okay, if you've got a quorum meeting for breakfast and they're just talking about their families, they're talking about the weather, they're talking about their favorite sports teams, that's okay. They can get together and go ahead and have that breakfast. Okay, it's when they start talking about the business of the township or the business of the borough, the business of the authority, the business of the school district, whichever. Okay, that's when they get themselves into trouble. Okay, because that then meets the definition of deliberation. And when you're deliberating, it must occur in a public setting, and that must be sunshined. Okay. And then we come up to decision making. Is there decision making taking place? And, for our purposes, decision making is when you take a vote, whether it be, an official, all in favor, say aye sort of vote, or if they just kind of poll the room and say, well, what do you think? What's your opinion? How would you vote? Okay, well, that constitutes a vote. That is decision making. This is what we're going to do. All right. And then I want to caution any public officials about email meetings. Okay, when it comes to matters of policy, and this usually occurs at the beginning of the business year where you've got a new board seated, maybe a new chairperson. That chairperson comes from a business background and they're thinking, well, it would be a lot more efficient if we just take care of this using email. So I'm just going to poll everybody using email and, it'll take care of it much quicker. Well, if you're exchanging emails, you're having a de facto meeting because you're deliberating and you're making decisions. And that very well would be a violation of the Sunshine Act. So even though it's efficient, even though it's very businesslike, and we need to run government more like a business, quote unquote, there's a very good chance you're violating the law and you can find yourselves getting into hot water over it. Now, I want to distinguish, however, between matters of policy, things that you would typically vote on in a public meeting, and matters of administration. It is okay to deliberate on matters of administration using email. Let's say that last month at the public meeting, the board, in front of everybody, voted to approve expending $1 million for street improvements in the borough. Okay, the vote has occurred. Okay, the vote passed. Now we need to decide who the contractor is and which streets are going to see the paving improvements. Okay, the vote has already taken place. The board voted to spend the money. The board voted to pave streets. Now, the administrative side as to how we're going to implement the approved decision that we made in public needs to be made. That is administrative in nature, and that can occur via email. Okay? Hopefully you see the distinction. The decision was made at a public meeting. How we're going to implement that decision can occur outside of the public because now we're talking about lesser decisions of an administrative nature that need to be made in order to implement the passage or the official passage that occurred at last month's previous meeting. And this could be something as simple as we need to change the time of the executive session that we're going to have because of a scheduling conflict, something like that. Okay, but be careful. Be careful because sometimes it's a gray area between what is policy in nature and what is administrative in nature. And again, lean towards transparency if there's any sort of questions. But I just put that out there because we see this happening more frequently where email meetings are occurring and it rises to the level of a potential violation. So just be cautious about your use of emails and what is discussed and how it's discussed. Okay, so you don't find yourselves getting into hot water. Okay, well, what is not a meeting? I just got done talking about administrative action versus agency business. Then we run into what are called work sessions. And typically school boards are a big user of work sessions where, yes, once a month they have their business meetings that are open to the public, but also once a month, maybe on the opposing 2-week cycle, they have what are known as work sessions. And typically a work session is a gathering of the board where the communication is somewhat one-sided. They'll have the superintendent, maybe some principals, some assistant principals, some assistant superintendents, some assistants to the assistants, and they stand up and they make presentations to the board on matters of import, updates on projects, issues that need to be dealt with at the regular business meeting. The purpose is to educate the board so that they can make informed decisions. Now, board members can query the person making the presentation, okay? And you can have conversation back and forth. But the board members themselves, amongst themselves, cannot discuss the merits of what's being presented because that is deliberation. And remember, deliberation must occur in a public setting. Okay, question has popped up. Can a couple of members, not a quorum, discuss policy items without triggering the application of the Sunshine Act? It is possible, but you need to be very careful about how that discussion may extend to other members of the board that ultimately results in a quorum having a de facto discussion. There was a case in the city of Philadelphia years ago where in order to avoid the Sunshine Act, they would divide up into 4 subgroups, each in a separate room. And the president of council then ran round robin, having the same discussion with each group. And there were complaints filed, and I think it ultimately did go to court, but before a decision was rendered, the council, I think they backed off. But anyway, you can see how they were getting themselves into trouble by intentionally attempting to subvert the Sunshine Act. Okay. And, it's a good example for me to say, don't try to outthink the act, because ultimately you'll find yourselves getting into trouble. Okay. There are no secrets, or if you think there are secrets, you're mistaken, because ultimately it all comes out and you find yourselves getting into hot water when you try to outthink the law. Okay, so don't do that. But good question. My recommendation is try to avoid these discussions, okay, outside of regularly scheduled gatherings. Because again, you could find yourselves getting into hot water, even though you didn't intend to subvert the law. Good question. Keep them coming. Oh, yeah. If committees do not have a quorum but are deliberating, do those meetings need to be sunshined? Well, no, they do not, because remember, the first thing that determines whether or not it is a meeting is whether a quorum is present. And since there is not a quorum, you can't conduct any official business. So it really doesn't rise to the level of a meeting as far as the Sunshine Act is concerned. Do you see how that logic works? If there's not a quorum, you don't have enough to vote, so it's not a meeting. Okay, good, good. Okay, keep the questions coming, folks. These are good ones. All right, so with a work session, communication is one way. There's no deliberation, because remember, the board members cannot discuss the merits of the presentations amongst themselves. And there's no decision making. No one needs to take, or no one is taking a vote. Now, I do want to caution you. Occasionally, we will see work sessions where all the provisions of the Sunshine Act have been met. Okay, it's been advertised, the public's allowed to sit there, the public can even comment if they want to, but it's still called a work session. What that does is throw cold water on the public with the expectation that no business is going to take place, even though they complied with the Sunshine Act. And occasionally you will see a vote take place at a work session. Well, because it's labeled as a work session, not many people attend. And it's a strategy that's misused by some. Sometimes we'll see the term committee of the whole. All right. And right away, that throws up a red flag, because you've got a full quorum there. You've got deliberation taking place, and you've got decision making taking place. But because it's called a work session of the committee of the whole, the public's expectation is, well, no business is going to take place, so I'm not going to attend. All right, you see what's happening here. And while we don't have any case law on it, I think it's just a matter of time before someone files a complaint and a judge rules, nice try, guys, but I'm going to level fine at you, or some sort of a sanction here, because it was a public meeting and you called it a work session rather than a business meeting. And that's not right. So like I said, currently there's no case law on it, but I think it's just a matter of time before we see that happen. Okay, moving on. And let me get a sip of coffee here. My throat's dry. Okay, another leg of the stool, public notice. Under the Sunshine Act, there needs to be at least 3 days advance notice of the first regular meeting of the year. Okay, and this is typically, if you're following your code, it's I think it's the first Tuesday in January, where most government bodies need to have their organizing meeting. Okay, so in advance of that meeting, at least 3 days, okay, it has to be advertised. And typically, it's along with all the other meetings that would be scheduled for that business year. So if you're meeting monthly, maybe you meet on the first Tuesday of the month. So you would have the dates within the calendar year in your advertisement. And if you meet for your organizing and someone says, well, wait a minute, I have a conflict. I'm not available the first Tuesday. Can we make it the second Tuesday? Well, then you simply re-advertise those remaining meetings and you'll be fine doing that. You do not have to have a separate advertisement for every meeting. You just have to have all the expected meetings to be advertised in advance, and you can do it at one fell swoop at the beginning of the year with that legal notice. It needs to be a legal notice in a paid newspaper of general circulation. Newspaper articles, or what's known as puff pieces, don't count. It needs to be that legal notice that you pay for. Websites don't count. Now, if you're using your website or Facebook page or some other form of social media to get the word out to the public of your meeting schedules, that's great. But in addition to that, you still need to have this legal notice. Sales circulars, those free flyers that you get 2 or 3 times a week in your mailbox, they don't count. It needs to be a paid newspaper of general circulation, also needs to be posted at the meeting site. Now, I recognize that there are major structural changes occurring in the news media industry, and it is becoming harder and harder to get these legal notices published. All right. But this is what's in the law currently. And if it is a problem for your municipality, I suggest that you express your concerns to your legislators. Okay, let them know of your concerns and see if there might be a solution that they can take care of legislatively. But until that day comes, this is what the law says. Okay, another question has popped up. Is this true if conducting a public meeting and quorum hasn't yet been established, but ultimately the purpose is to vote on the matter being deliberated? Okay, again, if you don't have a quorum, then legally the board cannot take official action. And since they can't take official action, it's not a meeting per the definition of the Sunshine Act. You must have a quorum present of either the elected board, if it's a board meeting, or if it's a committee meeting, a quorum of the committee meetings of the committee board in order for them to take any sort of official action. If you don't have a quorum, you can't conduct business. Okay. And if they sit around and just talk, well, that's not deliberation because a quorum is not present. But don't attempt to have some form of deliberation by avoiding having a quorum present. Okay, I hopefully you see the logic that I'm using here. If there's not a quorum, it's not a meeting. Okay, because that was the first factor that needs to be satisfied. But you want to be very careful about having deliberations, even if a quorum isn't present, because that conversation could ultimately extend to enough members that it does represent a quorum. Okay, a conversation doesn't have to occur all at the same time. Okay, you can have the same conversation one at a time with members of a board that ultimately represents a quorum, and you find yourself getting into trouble. Okay, so you want to be very careful about that. All right, so I think we've covered the public notice. We've also answered another very good question. Let's move on. Oh, public notice continued. You can have special meetings in addition to the regular meetings. Okay, let's say some matter of business has come up that can't wait until next month. So we need to have a special meeting in order to vote on this issue. Under the Sunshine Act, for special meetings, you need to have at least 24 hours advance notice rather than the 72. All other conditions are the same though. Paid newspaper of general circulation, posted at the meeting site. You can also have emergency meetings where there is no requirement for prior notification, but it must be a bona fide emergency. The example I like to use is a snowplow. We're a small borough. We've got one snowplow. That's all we've ever needed. but it's on its last legs, and sure enough, it broke down and we can't get parts for it anymore. And the forecast says that there's a big storm on the way. We need a snowplow. Okay, well, let's have an emergency meeting so that we can discuss going down the road where they have a snowplow sitting on the lot, and we'll purchase that one because we need it for tomorrow night's storm. So we have an emergency meeting, we vote on it, and we go buy the snowplow. Okay, bona fide emergency justifies having an emergency meeting. Do not attempt to create your own emergencies, though, because again, you find yourselves getting into trouble. Don't try to outthink the law. Okay, and then if there's a cancellation, whether it be regular, special, whatever, there is no legal requirement for any sort of posting that we're canceling the meeting. But I still recommend using your social media and whatever other means you have available to you, get the word out that you're canceling your meeting. You know, maybe someone is ill, scheduling conflict, whatever. Um, because what happens is people will go out of their way to attend the meeting. They show up at the township building, all the lights are out, the doors are locked, and it's crickets. Okay. That upsets people. So try to get the word out using your social media for any sort of cancellation. Okay, more questions have popped up. Is the physical quorum requirement before call-in votes can be taken only for boroughs and first-class townships? Yes, okay. I'm not aware of any codes that also cover this. First-class township code and the borough code. All right, what are the specifications on a special meeting when it comes to posting it? Yes, paid newspaper of general circulation. It's just that now you only have to have it posted 24 hours in advance of the meeting. And keep in mind the publishing requirements for some of these newspapers is usually a couple days. So don't wait until the last minute, or it may not be published 24 hours previous to the meeting. Okay. And again, it's becoming harder and harder to go ahead and do this. Right. If a board adjourns a properly advertised meeting to another date, does the new date when the meeting will be reconvened have to be advertised? Yes. Okay. It really isn't the same meeting at that point. Okay. It becomes a special meeting because it's not on the pre-advertised date. Okay. I've seen this happen in the past, and it's always left a bad taste in my mouth where um, you have a meeting, it gets late. Well, let's adjourn for tonight and we will reconvene, you know, on Thursday night. All right. That's a problem. Okay. Because the public is not aware that you're going to reconvene on Thursday night and that business may take place on that night. So I believe you're actually having a special meeting to continue the business that was not concluded during the regular meeting. So you should advertise that reconvene gathering in order to comply with the Sunshine Act. Yes, Mark, no cancellation is required, or I'm sorry, no advertising is required for cancellations. All right. In reference to emergency meetings, can it be done by phone? Yes. Okay, because it's an emergency. Regarding agenda meetings. Okay, I'm going to get to agendas when agencies have public hearings contemplating permits. All right. You're confusing a hearing with a meeting, and there is a difference. And I'll get into that. Oh, I think I get into that in this, but no, I don't think I do. So let's talk about it. There is a difference between a hearing and a meeting. We are talking about public meetings where business is conducted. When you use the term hearing, like zoning or building permits or whatever, that's something different. Those are not covered by the Sunshine Act, okay? They are covered by the specific act that governs zoning hearings, like the Municipal Planning Act or code enforcement and the like, okay, when it's an adversarial hearing like that. Um, Okay, when advertising public meetings with a Zoom option, must we include the Zoom info or can we say it'll be supplied upon request? I would suggest having that information available with the posting, but I realize that that may not always be possible. I think as long as it's apparent you're making a good faith effort to include the public in your online presence, that's fine. Because back when we had the pandemic and Zoom was first used, there was Zoom bombing, where people would come in and disrupt the meetings, and it was acceptable at that point, say, call the office and we'll give you the link to the meeting. Okay, so I think you can still do that as long as it's apparent it's a good faith effort to include the public and it's justified because you don't want to risk having someone from outside come in and disrupt your meeting. Okay, so I think you're okay there. So emergency meetings don't have to be open to the public. Yes, I think I've made that clear. Okay, good questions, folks. Keep them coming. Okay, moving on. Agendas. Okay, this is a somewhat newer provision to the Sunshine Act, although it's, I think, 3 years old now. It was passed by the legislature in response to complaints from the public that we have no idea when our public officials are going to be voting on stuff. A lot of times they will throw stuff in at the end of a meeting that takes everybody by surprise, and it's going to result in raising fees or raising our taxes or whatever. That doesn't seem right, and the legislature agreed. So what they did was pass this provision that now requires, prior to any public meeting, the governing board must post an agenda on all issues to be deliberated or any planned official action at least 24 hours before that public meeting takes place. And this includes regular and special meetings. Now, it wouldn't include work sessions because no official action takes place at a work session, or executive sessions, which we're going to talk about here in a little bit. The agenda needs to be posted on a website if you have one, or if you're using Facebook as your main social media presence, well, then you post it on your Facebook site. Okay, there needs to be a posting of the agenda at the agency offices and at the meeting site. And then it also needs to be available to hand out to the public as they're coming into the meeting. Okay, so there needs to be copies of the agenda available for them. Now, the timeline is such that, oh, question has popped up. Okay, comment on a draft permit. Okay, that is also governed by statute. And you want to take a look at I believe it's the Municipal Planning Code, okay, which spells out how these notification hearings and notification meetings take place, okay, because for draft permitting, it goes beyond the 24-hour and 72-hour advance notice. I think it's like, in some instances, 30 days, 60 days. Admittedly, I'm not up on that code, but I believe that's where it's covered, Elizabeth. So you want to take a look at that for clarity on what your posting requirements are. That's separate and distinct from the Sunshine Act. All right. If you normally post on your website but are having technical difficulties doing so, is a Facebook post acceptable to meet the requirements of the law? Michelle, there's nothing in the law that addresses that. There is no case law on that yet. I would caution against it. There is some case law where there were technical difficulties with attending a meeting and the public was shut out and the court said you have to do a do-over, that any business conducted at that meeting is now void because of the technical difficulties. If you can't get the agenda posted on your website and you have a website, I'd say that's a problem. and I would do whatever you can to avoid that problem. Now, if you don't have a website and Facebook is your only social media presence, then Facebook is acceptable. Okay, so let's talk about the timeline, okay, and how this all works. All right, hold on. The questions are keep coming here. Are agendas required to be posted on the website and meeting site? Yes, okay, both, not either or. Where should the agenda be posted again? Well, website or Facebook page if you don't have a website, or both, the business office, and the meeting site. And then you have to have copies of the meeting, or I'm sorry, copies of the agenda available at the meeting as well. Now, talking about the timeline, changes to the agenda prior to the 24-hour window, anything goes. If you have to change the agenda, you can, and you don't have to worry about any sort of posting requirements. But then 24 hours kicks in prior to the meeting. At that point, the only changes you can make to the agenda are what are legally called de minimis, meaning the changes would result in no expenditure of funds or we're entering into any sort of contract. Okay, so it's just small stuff that you can change. Okay, now the 24-hour window has expired and the meeting is called to order. Okay, once the meeting is called to order, changes can be made to the agenda, but only by majority vote. Okay, if a suggested change is brought up by the public during maybe some sort of public comment, the board doesn't really have to do anything. Okay, but they can defer it to a future meeting if they want to. But if the change is initiated by the board itself, you need to take a vote. And the reason is because votes are official action, which must be recorded in the minutes of that meeting. So actually, it's possible for two votes to take place. The first is that we're going to change the agenda by adding this particular subject. And you must announce during the meeting why you are changing the agenda. So the chairperson stands up and says, we are changing the agenda because, and they explain. Then they take the vote. All in favor? Aye. Okay, so they've decided to change the agenda. Now the potential exists to take a second vote on the item itself. It's possible that they may decide not to vote on the issue that they just deliberated. Maybe they decided, well, maybe we really shouldn't do anything about this, so we're not going to vote. But maybe they decide, yes, we are going to vote on this new agenda item. So they take the vote. All in favor, say aye. The vote takes place. Now the minutes reflect two pieces of official action. First one is to change the agenda. The second one is to vote on the agenda item itself. Okay, that matter of business. And it is all memorialized in the minutes of the meeting. Okay, the minutes must reflect the change. Now, if the agenda is amended, that amended agenda must be posted within 24 hours after that meeting has adjourned where the agenda was changed. So people ask, how long does it need to be posted once we put it up? The law doesn't say, and there's no case law that defines this. So I'm going to say, and this is just George talking, this is not what the law says, this is not what the courts say. Since there is a 24-hour window prior to the meeting for agenda changes, it makes sense that there would be a 24-hour window after the meeting for how long the changed agenda needs to be posted. But like I said, I want to caution you, this is just George's logic. It is not the legislature. It is not the courts. Okay, if at some point this does get litigated and a judge says, well, George is wrong, you know, take it with a grain of salt. But that's what I would do. Okay, another question. Can an agenda be changed by majority vote of the board during a meeting if the issue is not de minimis? Yeah, I don't think you followed my logic. De minimis is only during that 24-hour window prior to the meeting being called to order. Once the meeting is called to order, you can change anything. It just needs to be by majority vote. Entering into contracts. And what was the other item? Okay, you are welcome to go back and look at the PowerPoint, okay, because this was covered, but it involves the expenditure of any funds, okay? So I think it would be helpful if maybe you you looked at the PowerPoint once we've concluded here. Okay, let's move on. Public comment. Okay, commenters can be limited to residents and taxpayers. Anyone else coming in from outside the jurisdiction, the board can say, no, we're not going to allow you to comment. Okay, and that is perfectly legitimate. Okay, and the way the law reads is that they have the right to comment on issues that are or may be before the board prior to any pertinent votes. Now, that word may kind of opens up a can of worms here, because even though potholes aren't on the agenda, if someone wants to stand up and complain about the potholes on their street, well, that may be an issue that would ultimately come before the board. So legally, they can do that. Okay. And don't get into the habit of shutting someone down because their comments aren't relevant to the business at hand. Okay. Because the federal courts have found that that is abridging a person's First Amendment rights. Okay. So be very careful about shutting a person down during public comment. Now, the board, though, may establish reasonable rules for public comment. Typically, it's time limits. Okay, everybody gets 3 minutes, or maybe everybody gets 5 minutes. But the board can also modify those rules, okay? Typically, you follow Robert's Rules of Order. Well, Robert's Rules of Order allows you to set the rules aside under special circumstances. And maybe tonight we've got something on the agenda that is really important. So maybe we want to give everybody 5 minutes rather than 3 minutes. Okay, well, we're going to amend the rules for tonight's meeting. Everybody gets 5 minutes. Or let's say it's a really hot button issue. A lot of people show up and a group comes in, they're all wearing the same t-shirts and they all sign up for public comment. Well, there's absolutely nothing wrong with the chairperson approaching that group and saying, look, wouldn't it be okay if you guys appoint a spokesperson? We'll give them 10 minutes to cover all the important points that you want to get covered. That way, we won't be hearing a lot of repetition. In that way, you guys will be adequately represented. And everybody agrees, and you know, everybody's happy. Okay, public comment. Isn't this provision limited to political subdivision? Yes, taxpayers and residents. Okay, that's what I mean. People within that political subdivision. Okay, then we run into specific versus general comment. And let me see if the next slide covers this. No. Okay. This is not part of the act. However, it's something we recommend you take a look at. This was brought to our attention by a number of municipalities that adopted this practice, and it seems to work for them. They have a specific comment period, meaning that the board is getting ready to vote on this specific topic. So we're going to have public comment and we're going to limit it to comments about this topic. And then at the end of the night, we open it up for general public comment. So Joe Citizen can stand up and complain about the potholes on his street, even though it wasn't part of the board agenda. Okay. That seems to be successful. And like I said, it's not part of the law, but maybe your municipality, if you're having issues with public comment, want to take a look at it. Okay, and just see if it works for you. Okay, let's talk about executive sessions. Executive sessions are gatherings of the board that can be held outside of the public eye, typically to discuss sensitive issues that they otherwise would not discuss in a public setting. Okay, now executive sessions can be held before, during, after an open meeting, or announced for some future date, as long as it's clear that the public was aware of the executive session taking place. Okay, you need to give the complete reason for why the board is going into executive session. A chairperson can't simply say, we're going into executive session for personnel reasons. And this is outlined in case law. The citation is the City of Reading versus the Reading Eagle, which is the local newspaper in Berks County. And that was happening. Chairperson would stand up, we're going into executive session for personnel reasons. The Reading Eagle filed suit, said that's not good enough. You need to tell us more. And the courts agreed. It went all the way up to the Pennsylvania Commonwealth Court, and there was language in the Reading Eagle case where the courts basically said, you need to give enough of a reason to satisfy the public's trust that you're meeting in secrecy for a good reason, a valid reason. Okay. So, for instance, rather than saying just for personnel reasons, you would say something to the effect, we need to discuss whether it's appropriate to suspend one of our employees due to a work rule infraction, something like that. Or the borough is being sued in common pleas court by this company. Here's the docket number, and we need to discuss some legal matters with our solicitor. Okay, a valid reason for going into executive session and sufficient explanation so that I, as a member of the public, can trust why my elected officials are meeting in secret. Okay, I'm kind of paraphrasing what the law says, but that's the gist of the Reading Eagle case. Okay, now when a board does meet in executive session, there's no requirement that they keep minutes, but if they do keep minutes, they are exempt from public disclosure under the Pennsylvania Right to Know law. No official action can be taken during an executive session. Okay, you can poll members of the board saying, well, what do you think? How would you vote on this? But the actual vote must take place when they reconvene in public setting because it's official action. Okay, so let's say that they all agree in executive session, yeah, this was clearly a violation of the work rules. We need to suspend this employee for 5 days. Okay, so they all agree on that. They adjourn the executive session. They return to or come out into the regular public meeting, reconvene, and then they take the official vote. Okay, all in favor of suspending this employee for 5 business days, signified by saying aye. And they take the vote, it becomes official action at that point. Okay, and it's memorialized in the minutes of the board. Okay, that's how that all works. Any decision that would occur during executive session would, and it's considered an official decision by the board, would constitute a potential violation of the act. Okay, will the audio recording of today's session be made available for review? Yes, maybe you missed the beginning comments, but this session is being recorded and it will be available on the OOR's website. Okay, moving on. Okay, executive sessions. Why can you have executive sessions? Well, personnel matters, like I said, hiring, firing, discipline, discussing labor negotiations, considering the purchasing, leasing, or selling of property. Okay, the law does not say selling, but there is an unpublished Commonwealth Court decision where the Chief Justice drew a nexus between if you're going to meet in secret to purchase property, you can meet in secret to sell property. And, it kind of makes sense when you look at it from the big picture. Consulting with counsel about litigation, avoiding violating privilege or confidentiality. Okay. Privilege is sensitive discussion between your solicitor and the board or providing legal advice. Okay. And sometimes your solicitor might say, we need to meet in an executive session right now in order to prevent a public official from saying something that could come back and cause problems for the board. So they will meet in an executive session to clarify what you can and can't say in public. Okay. Discussing university admission standards. This goes back to 1950s. Discussing emergency preparedness, like your homeland security issues or your emergency preparedness sort of stuff. Okay. Valid reason for meeting in an executive session. All right, public comment, isn't this provision limited to, okay, and then we have versus executive office and general assembly committees. Okay, public comment, yeah, you raise a good point here. I didn't, and I usually mention this. Public comment is limited to local agencies, cities, townships, boroughs, school districts, authorities, the General Assembly, and agencies under the governor's jurisdiction, meaning Commonwealth departments, boards, state commissions are exempt from the public comment provisions. Okay. I should have made that clear, but Jason, thank you for that, reminding me to clarify that. Public comment, local agencies only. Okay. Violations. Let's talk about this quickly. During a public meeting, it is acceptable for a member of the public to bring it to the board's attention a perceived violation of the Sunshine Act. Meaning I can be at a public meeting and I can stand up and can be completely within order and say, I believe you are currently violating the Sunshine Act because, and then I sit down and I can do that. I am not out of order. Now the agency, let's say that the board listens to me and they say, you know what, George is right. We did just violate the Sunshine Act. They get a do-over. They can cure the perceived violation by maybe taking the vote over again or allowing public comment before they vote. Whatever the perceived violation was, they can cure the violation and it's no longer considered a violation of the Sunshine Act because they cured it. But let's say that, oh, George is full of it. Okay, he's wrong. We're not violating the Sunshine Act. Well, if I still believe that there is a violation, I have 30 days in which I can go to court to seek legal relief. For a local agency, I would go to my county court of common pleas. For a state agency, I would go to the Pennsylvania Commonwealth Court. If I believe that there's some sort of criminal activity, I could also go to the county district attorney. Now, the district attorney can only investigate and rule on the criminal allegations that I'm making. They cannot rule on whether or not there was a violation of the Sunshine Act. Only the judge can do that. Typically, what a judge will do is hold a hearing, and this is where that straight face test comes into play. Okay, and both parties stand before the judge and argue their case. Now, if the judge concludes that yes, there was a violation of the Sunshine Act, they have a great deal of leeway in what they can do. They can just simply slap the agency on the wrist and say, yes, it was a violation, don't do it again. They can void a particular vote. They can void an entire meeting, or if they think the violation was particularly egregious, they can invoke sanctions. The law allows them to levy a fine of $1,000 on each public official or public employee who they believe was culpable in the violation. The sanction, the fine, cannot be paid by the municipality. It must be paid by the public official. It comes out of their pocket. Okay, so it starts getting painful, okay? And I want to say this doesn't happen that often, okay? I don't hear of it happening a lot. But, you catch a judge on a bad day and look out. So the fines are paid by the officials, not the agency. In recent history, this is interesting, judges have required public officials to go to training on the Sunshine Act. And I found myself doing that. They say, go to the Office of Open Records and get training. So we've conducted special sessions and then notified the judge that XYZ public officials have officially attended approved training on the Sunshine Act. And, that satisfies the judge's ruling. So it's getting interesting. We're seeing more activity on the Sunshine Act in recent years, and judges kind of going outside the box in how they rule on these cases. But it's kind of an interesting trend to watch. Okay, moving on. Just some miscellaneous stuff before we conclude here this morning. Agencies must produce meeting minutes recording board attendance who voted for and against, okay? This is usually a requirement of the appropriate code that governs that board's jurisdiction, whether it be, borough, township, et cetera, et cetera. So you have to have minutes. It has to say who was there, and if there is a vote, how they voted, up or down. If there was a roll call vote, you need to record how each member voted. Okay, this is what's specified in the Sunshine Act. You also want to be familiar with what your particular code says on how you record votes and how you keep minutes. Now, the public can record meetings unannounced, meaning I can take my cell phone, set it on record, put it in my pocket, go into the public meeting. I don't have to say a word that I'm doing this. It's not a violation of the Sunshine Act. It's not a violation of the Pennsylvania wiretap law. What we recommend is at the beginning of the meeting, when the chairperson is making their announcements, to also say something like there is no expectation of privacy at these public meetings, and this meeting very well could be recorded. And if the jurisdiction is recording the meeting themselves, that recording is a public record accessible through the Pennsylvania right to know law. Okay, questions have popped up here. Do you have an opinion? No, I don't. On whether or not a local agency should make video recordings of its meetings and how long those recordings should be available. Okay, my opinion is not a legal opinion, but as a best practice, I'm going to say yeah. If you can record your meetings and post them to your websites, if you can live stream your meetings, and I realize, this is expensive. It requires resources. It requires people with expertise. Not everyone can do this, but there are a lot of municipalities, school districts, authorities who do live stream their meetings, and then they keep the recordings available on their websites for as long as disk space allows them to do so. That they can. Okay, I think it's a best practice. I think it's something that the public comes to expect, and it really can solve more problems than it creates. Okay, how long should these recordings be available? You know what? If you're recording your meetings, there's another law in Pennsylvania known as the Pennsylvania Municipal Records Act. It only applies to local agencies like boroughs and townships, but there they recommend 2 years. So I think that's a reasonable period of time to keep those recordings. There's no law that governs records retention with school districts and other jurisdictions like authorities, But I think 2 years is a reasonable expectation for keeping these recordings available. Okay, again, this is not a legal opinion. I'm not providing any legal advice or an opinion of the Office of Open Records. I'm just referring to what the Pennsylvania Municipal Records Act says and drawing a parallel and thinking, well, that's, that is logical reasoning. Okay, if roll call votes are in favor, can the minutes state roll call vote taken, all ayes? Yeah, I think that's reasonable. I think that's reasonable because because you still haven't recorded who was there. So everyone who was there voted in favor. Okay, and I can, draw a logical conclusion as to how a particular person voted because everyone voted in favor. Okay, good questions, folks. Good questions. All right. Are we at the end? Yes, we are. Okay. I've periodically referred to our website. Take a look at it. It is the best government website you'll find. If you have any other questions, now's the time to get them in before we conclude. But if we happen to conclude and questions come up, again, contact our office. The resources are on the screen right now. On the website, there is a page dedicated to the Sunshine Act, an FAQ section, I think some references to case law. Take a look at that. It will provide some additional information. The law itself is also on the website. You can download that for free, no problems. Anything you need to know about the right to know law is also on the website. And feel free to take a look at the entire website. How long must minutes be kept after the date of a meeting? Forever. Okay, minutes are considered the official action of that authority, and you're going to find per the code that governs your jurisdiction that minutes don't go away. Okay, you should have minutes for as long as your jurisdiction was incorporated. Okay, thank you for the generous comment there. Okay, if by chance you are a true government geek and want to know about everything there is to know about government transparency, subscribe to our Twitter feed. And every morning at 7 a.m., we will wake you up with a tweet with all the news of that day related to government transparency. Decisions we've rendered, court decisions that may have come down, training notices, news notices, anything you need to know about government transparency, you can find on our Twitter feed. Okay, so take a look at that. But I want to thank you for your participation today. Some really good questions came up, and just in time because I'm losing my voice. But we'll be back in 2 weeks with another webinar, and hope stay safe out there. Enjoy this weather while it's lasting, and yeah, have a good time, folks. Thank you for your participation. We're now going to log off.